Hello, M&A scientists. Welcome to the M&A Science Podcast. This podcast is part of a mission to rethink how M&A is done. The old school settle-led approach is dead. Buyer-led M&A is all about strategy, alignment, and efficiency, putting value creation at the center of every deal. Let's be real. It's not just about closing the deal. It's about making it successful. We uncover what truly works in M&A by learning directly from the best. For episodes, resources, and tools to elevate your M&A game, visit mascience.com and follow us on LinkedIn. If you find this content useful, don't forget to leave us a review on your favorite podcast app so others can find us too. I'm your host, Kisan Patel, founder and CEO at Deal Room and chief scientist here at M&A Science. Joining me today is Tina Kassangana, M&A lawyer, associate at Moritt, Hock, and Hamroff. Moritt, Hock, and Hamroff is a full-service law firm known for its expertise in corporate law, M&A, real estate, and commercial litigation, providing strategic legal support to help clients navigate complex business challenges. Today, we're going to talk about how to manage risk and liabilities in M&A. Tina, thanks for hosting me at your office here in New York City.
Yeah, welcome to the New York City office, and thanks for having me.
I love when we can make these interviews happen in person.
Sure.
Can we kick things off a little bit about your background?
Absolutely. So I am a fifth or sixth year associate. I always mess that up. But class of 2019, St. John's Law. I went to Syracuse University for undergrad, specifically international relations and poli-sci. Interestingly enough, I actually wanted to be a sports commentator, so not a lawyer. But I had done lots of mock trials since sixth grade. And I realized that I'm acing all of these, natural law theory classes and kind of flunking comms, communication. So I should probably look more into this legal stuff. Competed in mock trial, college, law school level, moot court at the Vis Moot second year, and a lot of professors are probably upset that I'm not a litigator, but I'm happily doing transaction.
You were like born for this as a kid, and then you had all this experience doing mock trials. Like, how does that flow into your practice today?
I mean, honestly, it's taught me to synthesize a lot of information and make it all work, right? So in mock trial, you have a closed universe of facts. Okay. And I was always the closer. So I need to know everything that's in that little binder. However, I also need to pay attention to what's going on in the current trial, right? So at the end of the trial, I now need to pick and choose what actually came in, what didn't come in from my little universe, and how do I need to make this work per trial? It's the same thing as an M&A deal, right? So there's the diligence. That's the universe, right? So if I do a tech company sale or fire suppression sale, I know the general universe of what needs to happen, but I need to tailor it to this deal. And for example, cross-examinations, that's just due diligence for me.
Yeah, I like it. It is a strong correlation there.
Yeah.
What have you done the last 5-6 years of this firm? What kind of deals have you worked on?
So we mainly are seller side, but we've also done buy side. We've seen a trend to more private equity. So this actually ties into when I started. When I started in 2019, the pandemic started, right? So I had to learn all about sell side, PPPs, escrow, figuring all of this out during the pandemic, quite frankly. But so we've done a lot of commercial businesses. We've done some accounting firms. So a lot of different areas of business.
Pretty well-rounded. I got to ask, how come it's always associate as a title for like ever, and then all of a sudden goes to partner? Why don't they have any like different steps in between?
Sometimes they do. So some law firms, they'll like differentiate the associate to like the senior associate to let you know that they're on their way on the up and up. But yeah, no, the associate track is a long time.
I just thought that lawyers aren't that creative, because you go to a startup, we'll take that into like 10 different titles. So you're constantly.
For sure. I mean, yeah, lawyers will just try to keep things as simple as possible when it's not deal related.
Fair enough. What stages in the M&A life cycle do the biggest risk happen or arise? And like how do they come about and how do we manage them?
So, I mean, as an attorney, I would say that risks come up in every stage. But the biggest ones, right, I would say there's probably three primary buckets. You have your financial pre-sell stage, right? That's where we talk about valuation risks, right? Then you have in the middle of the deal, you'll have your diligence risks, right? And then you'll have your post-closing risks where now, did things go to plan? Sellers and buyers are fighting over, earnout metrics. Someone, did a CapEx that was not supposed to be spent and that affected, the bottom line for calculations. Someone's upset that they're not actually running the business, which tends to happen with some of these smaller businesses. When they sell to a private equity fund, they're so used to running the business that now they're answering to someone else. And oftentimes there's personality clashes and some of those things can happen. And the risk that we try to mitigate at that point is, well, if something like that happens, how can we get you out? And how can we still maximize if there's anything on the back end, right, for your back end payments? A lot of people talk about valuation gaps and how to deal with that with earnouts, seller notes, which are, as a seller's counsel, usually I would not encourage, things like that. And you have to be very clear in agreements, right? So with earnouts, you have to figure out what are we actually looking for? What's the metric? Because it's not just revenue. It could be profitability. How are we defining profitability, right? And so sometimes, I mean, I've heard accountants sometimes say that adjusted EBITDA just means deferred lawsuit. So we will heavily negotiate at the jump to make sure that everyone's on the same page. What are the accounting policies that we're using to calculate? So that's a risk already that we're trying to mitigate at the start.
Can we role play this out?
Sure.
Let's do both though, because I'm always focused on the buy side,
Yeah.
especially like right now. I'm trying to look at deals and build a pipeline, and then we'll do the sell side.
Yeah.
So I'll be your virgin client, first time doing a deal, and part of it's like I don't even know how to work with an M&A attorney because I am that person that's gonna draft my own LOI, sign it, and
Please
be
don't.
like, hey, okay. So this let's start there.
Yeah.
Let's talk about. I got a company, so I got a couple of them actually in the pipeline that I'm looking at, and I'm probably at early diligence. Like NDAs are signed. I'm getting the initial numbers on both of these targets, and just got the first pass of diligence. So I got it. I'm starting to work at putting a model together, and it's looking interesting. I got a pretty good feeling that this is one we're definitely going to want to try to pursue.
Okay.
Am I talking to you yet or not yet?
Not yet.
Not yet. Okay. I get the model going, and then I'm starting to wrap my head around what this company is going to be worth. I kind of feel it out for them just to be like, hey, are we on the same page about this? I'm going to push them to do some seller financing.
What's the same page? So at this point, have you now already thought about some deal terms?
Yeah. For me, I'm always thinking the price. And as an early stage company, I want to hold on to as much cash as possible. And if I go to the market, I want to avoid equity because that's definitely a lot of firms reach out to us about that. But we're growing fast. We're growing over 40% year over year. So when I look at the third party debt market for a tech company, private capital is going to run around 16% unless you throw in a bunch of warrants in there. So then I'm like, wow, I'm trying to minimize that as much as possible too. So my goal would be to get the seller to take a bet with us, hold some paper and roll over some equity.
Okay.
Ideally like a third and third, right?
Yeah.
Hey, I figure out how to get you a third in cash, a third in hold some paper, and then a third we'll roll over in some equity so you can give you the promise of the next exit or recap for us.
Yeah. Okay. So based off of this fact pattern, right, this scenario, once you get to a point that you're actually really interested and you may set forth an offer, that's when you would call me. And also, since it sounds like you're very active in these transactions, you should probably just have also an attorney or a panel that are just kind of on standby who know that you're actively looking for sellers. So that way we already know what your main target is, what your main interests are. So what you just shared with me, when you come now with another possible target, I'm already thinking about that third. right?
So I want to get to know you
Yeah.
ahead of time, just know you.
Yeah.
And then, and you got an idea like, oh yeah, Kissan's out there trying to buy another tech company. And then once I get something in sight and I'm ready to put an LOI on the table.
Yep. That's when you reach out.
I come reach out you.
Yep.
Okay. So we did our analysis and we have an idea of what we want to pay. I have a good idea. And let's just say we'll use small numbers here. I know on this podcast we love talking about things in the billions, but I'm not doing that. I'm trying to they're losing the virginity on this deal. It's really small. So let's say simple math, like $15 million, because it's easy to break that in thirds, right? So $5 million we will pay in cash, and then $5 million we want seller financing with like, let's do a favorable, like 7% interest.
Okay.
Well, at least we want to propose it, right?
Yeah.
And then we want to roll over the equity.
Okay.
On the other piece.
All right.
That's what I'm thinking to propose. How's that sound? You know, like in terms of this, but I never done this LOI. What other things that should I be thinking about in terms that we would want to put in this LOI?
Right. So first, what kind of acquisition is it? Is it going to be asset? Is it going to be equity? Because that'll also play a part in how we're structuring some of the finances. It also play a part in employment agreements. Are we going to tie rollover equity to employment, right, to get them to stay in that type of retention? Most of the time, sellers, if they have like an office space or something, they're going to want that included in the LOI. Are you taking it on, or is it going to be excluded? So we're going to have to go more in a bigger picture in the LOI. Like, I hate to say big items, but it's usually the big items, you know, like the escrow. So in your 555, we also have to think about rep and warranty, right? So let's say, hypothetically speaking, this is a fairly new company, but they're very attractive and you're not really sure what you're getting. Out of that $5 million upfront consideration, how much of that are you willing to put in escrow? And the seller is going to come to us as your counsel in this case. They want the least amount of money in that escrow, right? So some of those numbers may have to change. So the 5 that's in the seller financing, we might take 2 from there to put it in the upfront consideration and ask for a bigger holdback or like a bigger escrow to cover for a longer period. So sometimes we'll have to play with the numbers like that.
Why do I care on the buy side about the escrow amount if it's all part of the total purchase price?
So you'll want to care because we have had situations where buyer doesn't care and then they realize, wait, I don't have anything to go to. Seller just sold their business. They don't really have anything behind for me to get money, right?
So I want this as assurance that, hey, I found out your numbers weren't what you told me, or some big thing changed.
Right.
Okay, so I'd want to do, what was like the typical percentage or range that I would want to do on the buy side? I
mean, 10% probably right now I would say is market.
Okay.
But also this changes with rep and warranty insurance.
Yeah, I was going to ask. So now that's the hot ticket item, which I think is like now like very mature. I feel like most deals use reps and warranty.
Yeah.
And I feel like you can buy a policy anywhere. Like people are selling that in the corner here in New York.
right at Canal Street, actually. No, seriously. I mean, we've seen, maybe 0.5, 1%. However, the buyer will probably take over the main fees, or they'll split it half and half with respect to the rep and warranty insurance and take that out of the proceeds. But yeah, rep and warranty insurance changes a lot of numbers and also changes the transaction documents.
Okay. So if I think most deals are typically asset deals.
Oh, I would say 50-50 I've seen.
Really?
Yeah, 50-50. Okay. Yeah. Asset deals get just nasty and weedy, especially when you have, buyers that are kind of like, yeah, I want everything. And then sellers who think that they don't have anything. And then you're pulling teeth. Like, okay, you do have stuff. You have furniture, you have equipment, you have inventory. Like, you have stuff. So we kind of need to disclose. And it's not just I'm selling my business, carte blanche, here we go.
Itemize all the assets.
Yeah.
Versus what I would think is the people component would drive you towards the stock sale, because that makes it smoother, especially if either people on visa or people in other countries.
Yep.
They were like, oh, let's just keep this intact and do it more as a stock. But then carrying some liabilities, like whatever they have pending.
Yeah, and so that's actually when it's a stock sale, we really get into some aggressive negotiations with the indemnifications and any type of, liabilities that are going to come post closing.
How do we manage risk? Like we're already at LOI and we're like talking about a lot of stuff, even just the structure between asset stock sale. That we talked about the holdback because we're going to have that, or we use a reps and warranty policy, which can help alleviate that. And then, it's a win because the seller will get their money and then they still get the assurance. And typically the buyer pays for that policy?
Typically, yes. We've seen that.
Okay. What are the things that we need to...
So you just mentioned we're past the LOI stage now, right? Everyone's happy. We sign. We're starting now some hardcore diligence.
Is that the main stuff though? Is it like, hey, here's the holdback, and then here's, are we going to go down asset versus stock? Because do we make that decision at LOI?
Yes.
Okay.
Yeah. Or you could say that, based off of tax counsel review, we may structure it asset or equity. So you don't have to be so set in stone with respect to the structure, but the items that you definitely want to have set: purchase price, who's going to come on afterwards, key employees, and any other obligations that is really important to either party that you want to fight for up front. We would typically suggest let's hash it out in the LOI already, even though it's technically non-binding.
So I could have like, hey, here's like 3 key people we've identified. Yep. Like we want to have retention on these 3 people that they're agreed upon. And then, it could be anything in terms of like, hey, this is sort of the must have. You said this thing, you had this license agreement secured for 10 years, and that's going to be critical to this deal. So let's make sure that's part of it.
Yep. And 2 months into the deal, we're still going to run some QV, whatever, but we need to see profit increasing at X amount, right? And then sometimes you'll have that, and there may be, a breakup fee if someone doesn't hit a metric or everyone walks away and, pays their own respective fees. So there are also things like that.
Is it pretty loose because this LOI is non-binding? Because I feel like there's a lot of diligence you can go to. Even I'm doing early stage stuff. I can figure out how to get to the value off the numbers pretty quick. But then there's a lot of like, okay, but, is this churn rate what they claim it is? Is there, any little thing like that? They said they don't have any, what's the termination clause in the customer agreements that,
accelerations, or what are you looking for?
Change of control provisions.
Okay. Yeah.
Like they said they don't have any change of control provisions in their customer agreements. And then I've had this before where all of a sudden you find out they had a bunch of change of control provisions.
Yeah, that's what happened.
Now it's like, whoa, how do we mitigate that risk? Because that's, big surprise. So like how, where do you strike that right balance? Because the other part of me is like, well, it's non-binding. Then we find this stuff out later. We'll just walk away from the deal.
You can. So part of the LOI is, trying to build a foundation, right? Of if we go outside of these bounds, like where then is the foundation going to completely crack and break? So as your buyer's counsel, I'm going to ask you, what are the things in this LOI that are binding for us, right? Not with respect to seller. And if you tell me I need these 3 key employees and something comes up in diligence about these 3 key employees, we can walk away, right? We can terminate and say that this was in the LOI. I've made it very clear that it was important to me. They can't sue you and then say that you're in breach because you promised X amount, right, for a transaction, and that these 3 key employees aren't going to come along, right? So that they might spend some money, they have to pay some fees, and then everyone just walks away. But the key thing about the LOI, it has to be flexible to account for the diligence, anything that comes up, right? And so that's the non-binding nature.
What about like the odd things that people bicker about towards the end of the deal, like working capital allocation and stuff like that? Like, do people put that in their LOI, or are they just like, it's like the routine to go at the table and pound your fist?
So the problem with working capital is the first issue is you bring it up at the LOI, that there's going to be a working capital adjustment that the parties are going to negotiate in the purchase agreement. It's one of those, we'll cross that bridge when we get there, but we're going to let you know that the bridge is there, right? And then when you actually get to the negotiations of the clause, that's when,
Okay. It's tough because all of a sudden you don't want to put too much, because then you're setting this tone like you're going to be a pain in the ass person to work with.
Exactly.
So, okay, fair enough. Okay, LOI signed. What happens next?
Okay.
Do I stop talking to you for a while? Do I just, do I start doing my diligence?
Well, no. So, and we're keeping buyer's counsel. I'm going to warn you at this point to be on the lookout for another NDA from seller's counsel. Even though you signed the initial NDA for the finances, now that we're going to get some legal due diligence, there's going to be another NDA.
Okay.
Because they're going to want to protect just in case if something happens. You've already seen their top customers, you've seen their top vendors. You shouldn't be allowed to use that. So don't be offended if they send you another NDA.
Step up the NDA.
Yeah.
Okay.
So there's that. Then I'm going to ask you to set up a data room. And we're going to prepare a due diligence request list.
As the buyer or seller?
Buyer.
Oh, this is cool because that's what we big advocate for is buy side M&A or buyer led M&A. And especially like a lot of roll-ups we work with, they have to control that process so they can plan integration better when they can drive the data room and the workflows around it.
Yeah. So you set the stage as buyer of what's the initial diligence request list. And obviously you can't think of everything that might pop up, but there are a few that I call like the crucials. You're going to need the legal. Can you sell this business? Who actually owns this business? If there are any tax issues. So sometimes if it's an asset sale and they're an S Corp, when did they do the S Corp election? Sometimes that messes with tax issues for them, not for a buyer. But
so I can set up all my requests in the data room and then the seller can fulfill all those requests.
At that point, they'll start uploading them and you'll also send it to their legal counsel.
I like it. You're like buyer led M&A approved. Like I want to work with you now.
Of course.
Yeah. And so we're going to go through this process. We put our requests in. I'm going to work with my different department leads because I want to know engineering's got their concerns and so forth.
Yep.
We'll consolidate that in our data room or deal room.
Deal room.
And yeah, there you go. And then we'll invite the seller to come in and start fulfilling these requests. And that starts happening. We'll start doing our diligence, and then we usually have a little findings area that we're going to centralize all our findings.
Yep.
And then what happens? Communication still goes with you. I know so at some point you got to put a purchase agreement together.
I was going to say, so as this diligence starts coming in, right, we're going to refer back to the LOI and touch base with you again. And at this point, we've probably already run a tax analysis. Best scenario for you, hypothetically, let's say you're going to want to go with an equity deal in this one. Right. And we're going to present to you why. We're going to give you the different tax implications for both, if you go both equity or asset. You'll make the decision based off of that. We will then prepare the purchase agreement in light of that. And we're also reviewing the diligence that's being uploaded in tandem.
Okay. So that's a big factor is the tax because that's like, whoa, what's the end picture going to look like financially? And then all these departments coming up with their findings and it's basically risk they're identifying.
Yep.
That, hey, there's this weird allocation they did from one year to the other. And we want to make sure that's what it is.
Yep.
Or HR finds another key person that we need to really retain. And give an example. I'm making stuff up. You got better examples?
No, I mean, that happens, right? Where they'll see a financial statement and say, what is this? What is this employee loan, for example, right? No, we don't have any employee loans. There's an employee loan in every single financial statement that we've seen. What is this? You will probably alert it to the business team, and you'll also want to alert it to me as counsel. So that way I can look at the financial reps and just flag it. If there's anything that I need to be mindful of, if there's post covenants with respect to taxes, right? How has this number implicated the finances for the company? And how then is that going to affect you post close? I need to think about that. But then seller side, their counsel is going to reach out to us and probably say, hey, you saw this, or my client told me about this. This is why they did it this way, right? And it may not even be an employee loan. They probably just booked something wrong, right? And now I need to go back to the purchase agreement and be mindful of they just did something wrong. Accounting wise, this is an issue, could potentially be a liability. How are we going to address this in the purchase agreement? And all of this, I'm going to tell you in a lot of emails.
You're drafting the purchase agreement on the buy side.
Buy side. We give the first draft.
And then you got to go back and forth with all basically departments that are reporting these risks.
Yep.
And you really need the clarification from them directly.
Yep.
And we always talk about who quarterbacked the deal. And I always thought as a person that runs the data room, but it's actually you.
So it actually is the person who runs the data room. So it's the most junior associate. On the legal side, at least, who's the most important quarterback. I can't make changes or revisions based off of facts and documents if they don't flow that information up to me.
Okay. So they technically quarterback it.
Yeah.
And you're, what is your?
I'm Pat Riley.
There you go. And then, okay. So you're on the coach. You're kind of directing everybody, making sure.
Yep. Everything needs to go smoothly, right? So like I know what the GM wants, right? I know what owners want. I know what the players want and what the coach wants. How can we make this all work?
That's a lot to coordinate to make it happen.
Yep.
What are like must-have things on the diligence list to reduce risk?
So, touched a little bit on this earlier, right? So it's understanding who owns whatever asset, company. You'll be surprised how many times there's an issue with that, right? Where it could be a family, trusts, right? For example, people pass away and then interest gets divided, et cetera. And sometimes things get messy. Or you have outstanding, equity from some other series or whatever, right? So we need to figure out the universe of who the owners are. 1. 2, can you even sell this thing, right? So that's the first bucket. I need yes to those first 2 things before I even look at anything else, because anything else comes back clear and you can't sell it, doesn't matter. After that, it's the financial diligence, which our tax partner will deal with that and let us know if there's anything, up with that. Then it's the contracts, right? So I need to be mindful of your business, what clients and customers you currently have, because there could be a contract that company is selling that you actually can't acquire because you may have a restrictive covenant in a current contract that would prohibit you from being in business with this other contract. So that needs to be taken care of as well.
That's the thing I got to learn. We'll talk more about the AI stuff later because we built some functionality around contract analysis. Mm-hmm. I'm like, wow, every company, I never think about it, even our own company, there's so many customer contracts. Yep. There's so many employment contracts. And then literally everybody, every customer has a contract. Every vendor has a contract. Mm-hmm. Every employee has a contract. I'm like, that's a big chunk of diligence to go through
contracts.
To go through that.
Yeah.
And I guess like when you start thinking about that, like what are the ways you start thinking about like risk and liabilities with all these different contracts, and like how do you prioritize?
So priority is actually with the structure. If it's an asset sale, I'm really going to look for the assignment clauses. If it's an equity sale, change in control. This is actually something that first year associates learn. A clause that's assignment, and AI would probably also have to be taught this. Right? There's very specific terms where you may read a clause and think that that's a change in control, and it's not. It's actually just prohibits, an actual transfer of the asset, not if the owners change. So there's that analysis. I also need to be mindful of any regulatory risks, right? Depending on the business that you're in. So I'm also going to target that. And it also goes back to the LOI of what are your key markers and what do you really need? Right. So I'm also going to look at loss runs for policies if we're talking about workforce. And depending on, again, your business, let's say there are 3 key employees that you want, right? And I'm going to also target for these 3 key employees, not just what are their salaries, et cetera. If I happen to notice that they have a workers' comp claim that comes up every 2 or 3 years, I'm going to flag that for you. Like, why do you actually want this guy? There's something that's popping up here. So everything is tailored. Like what I'm looking for in diligence is what the junior's looking for in diligence.
Based on that structure.
Yep.
So asset, you start looking for the assignments, equity / stock purchase.
Yep.
Change of control, those other areas. So these makes a lot of sense.
Yep.
Structure dictates like where you're going to start looking for risks in these contracts.
Yeah. And your obligations going forward, right? So in some of these customer contracts, there may be warranties that you're making, right? Can you even fulfill those warranties? There may be indemnification obligations that you're going to be taking on. Is that a risk level that you're willing to take, right? There may also be insurance requirements in certain contracts that you may not have currently. So how are we going to deal with that?
All right. That's a lot of stuff to get ready for this purchase agreement.
Yes. That's why there's like many drafts that go back and forth, because we're dealing with the information that's coming up in real time. So at the first draft, I may only have, financial diligence, for example. And then I get customer agreements, vendor agreements, usually on a Friday night before the weekend. And then I'm already thinking, okay, that needs to get changed now in the next draft of what's coming along. A good seller's counsel is going to make those changes with the documents that have been uploaded, right?
Yep.
But as buyer counsel, you also want to track everything that's coming in. What's the potential clause that this is going to trigger?
So I had to ask, what about the clauses that are more specific to post-close or minimizing post-close risks?
Mm-hmm. Yeah, so those are heavily negotiated. So, that's mainly for working capital. Let's use working capital.
Working capital, exactly.
Okay, so that's what, 90, 120 days afterwards. You have to be explicit in what's the time frame to give the report, right? What are the calculations? Is there a dispute mechanism? Are you going to go to arbitration? Have you already picked an arbitrator in like a dispute resolution like section in working capital? What are they looking for? If you're going to go with an independent accountant, for example, are they an independent finder of fact? Or are they just going to look at the purchase agreement? What are the definitions? Give me the numbers. That's it, right? So that's all of that is mitigating all of that risk and the fights and the liabilities that are going to happen down the line. It's a lot of upfront planning for structure of if this, then that, here's the resolution. Because everyone's happy now. Everyone just wants to get the deal closed, but we need to get into those details.
All the things that could go wrong.
Absolutely.
We spell them out. And then I guess, what does that look like in the agreement? Like, is there a specific section to list all those out? Is those all disclosures or?
So usually it'll follow whatever the issue is, right? Or whatever the topic is. So if it's working capital, there's probably a working capital mechanism, dispute mechanism there. Indemnification is another one that's heavily fought. Let's say there's a claim that comes in afterwards. Who's going to control that defense, right? Is it the indemnifying party or the indemnified party? Is that going to change anything? Do you get expenses advanced? Are there certain claims where you can get expenses advanced? Are there certain claims that are just barred, right? So we also need to think about that, and that'll pop up in its own section of the agreement. There may be other issues like escrow releases if there's, that 10% purchase price holdback, for example. That also needs to be set out in the escrow agreement of, okay, are we going to do joint instruction or are we just going to do, hey, here are the final calcs, send it over to the escrow agent and they shoot it out. But again, you have to think about all of these things.
The good old indemnification clause.
I love it.
I feel like almost every contract has some.
Has to, because there's always going to be something.
They need to negotiate it. Like,
yep.
No, you're responsible. No, you're responsible.
Responsible up to what point is always what I tell the clients, right? Up to what point? Because you're going to be responsible for something, but up to what point?
That's true. Disclosures, is that part of?
Oh yeah. Disclosure schedules is probably, I would say, the most negotiated bit in a purchase agreement.
Teach me this stuff. It comes up all the time and I don't really know the mechanics of it.
So disclosure schedules have, the best way I can explain it, it's you're making a representation at a moment in time, right? So at closing, seller is going to represent to you that their finances are, their tax returns are material in all respects, right? That as of this date, here are their top customers. That as of this date or between these dates, that they haven't had any litigation, for example. But then let's say it's 2 or 3 months afterwards, and then you get a claim, a litigation claim for something that happened during that time period. That's a breach of that rep.
Okay, so I want to tie the reps and warranty insurance on this because usually it's not like, I know we go to Canal Street and you go buy the policy, but they do a bunch of diligence on their own.
Yes.
Maybe walk me through that process of like how they actually like build that policy out to tie together with the purchase agreement.
So great example. I did buyer side rep and warranty insurance diligence, and it is, you want to talk about a detailed process, right? Everything needs an answer, and you're on a call. It's almost like a Senate hearing, quite frankly. You're on a call with the insurance company, And they're going to ask you questions like, why are we seeing this here? Like there's there's a potential for liability here. Are you sure that there isn't anything here, right? Or we notice this, we're going to carve it out. And now maybe that's something that you actually wanted covered, right? So the thing about rep and warranty insurance, it actually changes how you address the actual rep and warranty section. So if you have rep and warranty insurance, you don't want to be too specific, because if you're too specific, then it's carved out. If you're a seller, everything that you disclose on your disclosure schedules are carved out. So you want it to be as narrow as possible, right? And as buyer, you also want it to be as narrow as possible because you want to be covered for as many claims as you possibly can.
Right.
Now let's take the rep and warranty insurance out. And now it's just seller has to indemnify us if something happens.
Yep.
They want the broadest disclosure because they're going to say, no, I told you. That's done. And it changes the mechanics like that.
That's so interesting.
Yeah.
I never thought about it that way.
Mm-hmm. That's why lawyers are here.
Well, yeah. I admit it. Lawyers do a good chunk of the work.
Sometimes.
Pretty much do like 80% of the work in an M&A deal.
You guys do all the hard work. You identify them, and we just have to make sure you guys get to the finish line.
Yeah, well, as a principal now. I was going to say as a banker back in the days, we take all the glory and fame and credit.
Yeah. I hesitate to do that because I wait until like all the statute of limitations are done and like the rep and warranty survival period's done before I, start beating my chest and saying, yay, that deal closed, just to make sure everything's fine.
That's a good way to do it. That's a good way to do it. You still go to the closing table, the closing party. Yes,
we still do. Sometimes, although with the pandemic, I missed out on a lot of like the deal toys, a lot of the, the deal diet dinners or the $5,000 dinners, whatever. Occasionally, I'll be invited out, but I feel like I missed out on that really big era of closing dinners and toys and trinkets.
Yeah, that's true. That's true.
So let's bring that back.
Essentially, I know. Did they cut it out? I feel like they. I haven't seen as many. I didn't look in your office. There's not. Where's all the deal toys?
Yeah. No.
We gotta go to the banker's office. They always have a big showcase as soon as you walk in.
Honestly, that's right. Because every time I go to the bankers or like we're on a WebEx call with them, I definitely see their deal toys. I think it's stopping there. We got to bring it back down to the lawyers.
Yeah. There you go. Force majeure and contingency clauses. How are they evolving? How are they used?
Always evolving. So the problem with force majeure, right? It tries to mitigate what it thinks it's going to see, right? So you think, hypothetically speaking, what could happen that's going to stop this contract, that will stop me from performing, right? And
a global pandemic,
and then but you're also at the mercy of the courts, who will interpret this clause to say, is a pandemic the same thing as an epidemic? And like, if the thing with force majeure and the legal doctrine is you have to be explicit in what it is that you're carving out. So force majeure is fighting this tension of, I want to be as broad as possible, but legally I also need to be as specific as possible. But currently we have trade restrictions that may be coming up. So we'll have contingency that actually comes up with that, where if post-close there's something that happens, I'm going to speak very vaguely, there's an adjustment possibly to the purchase price, right? A lot of cybersecurity.
So that's different. So force majeure and contingencies. Force majeure is like, hey, it can get out of the deal.
Yep.
If something happens.
Yep.
But that's going to be in the purchase agreement, and then you're going to get out after you close.
After you close, potentially, yeah. So it's supposed to be like if there's a deal, I'm trying to think of if there's a deal that you cannot complete. Like you paid X amount of money, right, for it to close. And for some force majeure reason, you cannot perform. The party should be able to say, I can't perform this. It's done, right? I typically don't see it in a lot of purchase agreements unless it's in like a highly regulated or currently litigated sector. So you'll see a lot of cyber, AI, tech. That usually comes up at that point. Yeah.
And then the contingency clause, that's a little different.
Yes.
It's sort of like, hey, I can kind of almost like a little bit of a claw back on some of the terms if this variable occurs.
Correct. Yeah. And or if sometimes I'm sorry, I have to put my seller's counsel hat on, right? You don't want to deal with that. You just want to say, okay, what's the possible issue, right? So to give a concrete example, independent contractors, classifying them, right? That could change wages, finances, all of the financial flow of a company, right? And there's also depending on what are the penalties? How far back do they go? Who owes the penalties, right? As seller, I would tell them, take X amount out of that purchase price, set it aside. How long do we think it's going to be able to resolve? 2 years? 2 years. That's all we're giving you. If anything pops up after 2 years, that's not our problem, right? Yep. But as buyer, I don't want that. I want a contingency clause that's going to stay as long as the statute of limitations allows me to keep it in place, right? Because if it's year 3 and I can still bring in a claim, you better believe I'm bringing in that claim.
Two sides of the table.
Yeah.
You ever feel you're developing a Jekyll and Hyde sort of personas when you sort of see it on both sides and you're like,
Yeah, that's a mock trial in me. And if there are any astrology people, I'd say that's also my Libra moon. Being able to just see both sides. It's exhausting.
In deals that have multiple agreements,
yep.
I know issues with conflicts can come up. Do you have examples or how do you address those things?
Yeah, so you have to create a hierarchy of documents, right?
Okay.
So who's going to talk about some main provisions? Dispute resolution, indemnification, governing law, right? That's probably going to go in the purchase agreement. In the other agreements, employment agreements or anything else, right, you're going to refer back to the purchase agreement. That's the simplest way to do it, but not everyone does it that way. And there are other terms that need to be adjusted, in an employment agreement, indemnification, if it comes up. That's going to be tweaked specifically for that. The issue that tends to come up is with rollover equity, because you have these documents that they're not going to change them for a specific, and as buyer counsel, I'm not going to have 10 different equity documents that I need to track, right? There's going to be one, and you need to figure out how to fit into this one document. Now, buyer's counsel, I'm trying to figure out how to bring that document into every transaction, and there may be conflicting terms, right? So let's say a key employee has rollover equity. There's a clause for termination for cause, okay? He gets terminated for cause. That then ties usually to rollover equity. Rollover equity may have some notice provision, right, of triggering default, whatever, or what have you. We need to make sure that, is there a notice provision in the employment agreement? Is there a notice provision in the equity docs? There's actually an example where it was the reverse. The key employee wanted to leave, and they had an agreement in their employment of, this is how you need to leave. This is the calculation. How you need to leave. Here's the calculation, notice provisions, etc. Up to the point of, it needs to be FedEx mailed, blah, 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 blah. Now, as lawyers, we also have to look at the actual governing document. So that's the operating agreement or whatever. And it will have its own set of rules. If the lawyer who negotiated was really on, their stuff, they're going to say that the employment agreement supersedes any conflicting terms in that LLC agreement. So if that LLC agreement, I'm just going to say LLC, has a conflicting term, we're not going to go by it, right? Because then if we breach something, because we don't know which one to follow, that's going to mess up my client even more. So then you run into, we need to draft a letter, get them to release and waive that if we do it this way, it's not a breach, and that we're not in default, and that they then can't take X amount of money out of the purchase agreement because of whatever. They can't touch escrow. So everything kind of plays together, and you have to be mindful of that.
So if both agreements say that our agreement supersedes everything else, then you still got to, in this case, you got to negotiate it.
That's when you pick up the phone and you call the other counsel and say, hey, we both know that we negotiated this. That's your equity doc. This should probably be the one that actually governs. What's your risk for me not following that? That's the question.
It's a common sense.
Yeah. Sometimes it's hard to come by in deals.
Yeah, you got to go meet for a beer and
Yeah.
Hash it out.
Yeah, exactly.
Okay, so we have examples of the multiple agreements, which is a whole other dynamic. I'm thinking back to just things that pop up after the deal, and
A lot of it centers around rip and warranty, or financial covenants. Earnouts are always that's the big one.
Earnouts, and then equity agreements with employees.
Yep.
Let's chat a little bit about those, and then I had another question, the multiple agreement one.
Mm-hmm.
Okay, multiple agreement one, the jurisdiction and governance part of it, like that I was curious about, because like we're looking at a company out of the country.
Mm-hmm.
Like, when it wire comes to all this stuff that we're negotiating, we just talked about a lot.
Yeah.
What jurisdiction do you end up with? Because I obviously want it here in the U.S. They're going to want it in their domicile.
I mean, my hat on right now is as your counsel as buyer. They're coming here.
They're coming here. Yeah.
They're coming here. That's where we're going to start. And if, there's a well-reasoned argument as to why they can't, for example, let's say that, they're in some remote country. I don't know. Travel restrictions, for example, that could also be a thing that you do.
Is that common?
No.
It's not.
No. I mean, a lot of times in the U.S., it's always Delaware.
Yeah. In the U.S., it's simple.
Yeah.
Just as a buyer, I feel like I'm the one taking the risk.
Yeah.
But the seller is like, well, it's my house.
The thing is, now I'm going to Jekyll and Hyde it, right? As seller's counsel, I'm going to say, well, if you're coming to me and telling me that I have an issue, the least you could do is come to my backyard so that I could have my resources and let's hash this out, right? If you have an issue, come here, let's hash it out. Don't also give me the expense to then come to Arkansas, right? Which has come up sometimes, random states.
International arbitration court in the Bahamas.
Okay, so who's paying the flights?
Over Zoom.
Great. So it could also be a thing like that, where sometimes you have to figure out how to make it equal for both sides, right? So let's say you really want to do commercial arbitration in Bahamas for some reason, right? I don't know.
Okay.
Seller is like, absolutely not. I'm not going to do that, right? They might say, let's do a prevailing party cost like type of thing, where if I come down there, you're not only paying me what the judgment is, you're also paying my airfare, right? That could be something that's negotiated. Or you could say upfront, hey, I know that this is a crazy request to you, but it's really important to me. If something happens, like, I'm going to pay upfront the expense for one person. Now, see, when you start making offers like this, you have to be specific. One person, Comfort Plus, not first class, things like that, right? Where it's like, what are you willing to give to get that thing that you really want?
That's a lot to negotiations on how we're going to handle things to negotiate later or unnegotiate. I don't know. This is
But it's honestly, it sounds like a lot, but when we really speak with clients, we figure out there's usually like 3 key core things, right? Where I know that at the end of the day, I can't deviate from these 3 things. And then there are other things that you may be willing to, move the goalposts a little bit, right? So I might use that in order to get you your hard 3, right?
Right.
So we'll talk about it, and it may seem like a lot, right? Like in that scenario, the Comfort Plus, whatever Bahamas thing. But is it more important to you, the Bahamas versus the indemnification survival period? And if the conversation that we had is the survival period, I'm going to tell you, give up the Bahamas and we're going to fight for a longer survival period, because that's what you actually want at the end of the day.
Sounds like good guidance. How about going back to the earnouts and just equity agreements? Like what are the things that come up or the risks post-close on those? I hear about all the time. I hear especially earnouts. So often they end up in litigation. They didn't put the right, things on it, or integration sort of skews things. Somebody gets pissed off and lawsuits get filed.
Yeah. So
then you make more money.
yeah. Well, that then goes to litigation. But it's funny because we get looped back in because the litigators then ask us to translate the documents for them. Like, what is this? What's EBITDA? And we have to now explain that per the agreement, they were supposed to do this and they actually did this. So the thing about mitigating risks with respect to earnout, it's again, being really specific at the start. How are we calculating it, right? What is the actual metric that we are looking at, right? I mentioned it a little bit earlier, but profitability, top 3 customers, if that's what we're actually looking for. Who controls during the earnout period? How long is the earnout period, right? Seller is going to want as much control over that. But as buyer, this is your business now. You want to take control of it, but you also want to be mindful of, you don't want to make expenditures that are going to screw the earnout, over, because you also want to keep that relationship going great or going well, at least, because they're probably employed with you, the key principal, and you want to keep everyone happy as much as you can. Another thing about risks mitigating in earnouts, you can't go all or nothing. A sliding scale is your best friend, and it makes it a lot more palatable. Yeah. To, I missed it by, I missed the top metric by $500,000, right? But I'm still going to get X amount of money. So dang, even though I didn't max out my earnout, I still walked away with some cash. All or nothing is where it really gets nasty. And they're going to look at every single dollar that was spent to say, you did X, Y, and Z to make me miss that $500K.
I kind of bouncing between doing earnouts and seller financing. Earnouts are typically paid out annually for X amount of years. It seems like a typical term, right?
1 year, 2 years. Yeah. It's usually tied with employment.
And it's like a chunk at the end of the year, basically. Give you this. Versus seller financing, it's like a loan term. I'm going to pay you monthly with this much interest. Part of me is it makes sense. But then the other part's well, I can buy more time if I just got to, wait to pay the chunk out.
Yeah. I mean, the thing with the seller note also is, do you have any other debt? Right. How does it play in your financing universe? Now I'm putting my seller hat on. I don't want a seller note, because if you are a private equity fund, you probably have other debt. My debt's going to be subordinated. I'm going to be last in line. Right. That's money I'm probably not going to get.
Something goes wrong. Yeah. You got a chance of not getting that money.
Yeah. But as buyer, of course, I'm going to want that. You're giving me a seller note. How sweet of you. How kind, But I got, maybe 3 other lenders that need to get past you first, right? So, and it takes me a little bit more time, right, to pay X amount of money.
So if I don't have any other lenders, I can almost let you know, you'd have first lien, basically.
Exactly, and that'll make it much more attractive. And then based on your cash flow, also, you can figure out how long you kind of need for the seller note. I mean, a good seller is going to probably ask for a guarantee. For something. But yeah, so I mean, seller notes can be used well, but it can get a little dicey. And also remember that relationship is now being prolonged even further. Employment agreements are now 2-3 years, 4-5 maybe. A seller note can go even longer than that.
What are the terms you typically see on a seller note?
I've seen 5 years. Yeah, 5 years is it's probably your standard. Yeah.
Okay. But you could push to 7 or something. You
could push to 7. I mean, a lot of the sellers that we represent, this is they've built this business, they're selling it, and they want to retire in 2 years.
They're getting annuity out of it.
Yeah. So but then also because of that, we need to be really mindful of making sure that back end money is available.
Yep. Anything around the employment equity agreements that pops back up? I guess it's more around what we talked about earlier. If somebody gets laid off, what were the terms around that?
Yeah, if someone gets terminated for cause, if the other party, wants to terminate they just want to terminate, what are the implications for that? There's a lot of negotiations with perks, especially with sellers or key employees. As a buyer, you may say, hey, in our company, we have X amount of holidays, et cetera, and I kind of need to keep it uniform. So no, you can't have 40 days off, right? I also need you here. So those are that's more cultural risk and employment agreement risk that kind of ties hand in hand. And the employment agreement risk, along with the equity risk that we touched a little bit earlier, is what happens when this relationship ends, right?
Yep.
So do they keep their equity in the company? Can they be redeemed? Do they have to force you, buyer, to pay it back or to buy those shares back? And what's the valuation at that point? And again, that's something that we need to talk about now and not later.
Covered a lot. Oh no, I liked how we went back and forth, both sides of the table, Jekyll Hyde. If we were going back and putting more of that seller cap on, what are some of the key things that you would highlight in terms of things that you would really hone in on if I was going to sell a business? And I'm kind of creating a scenario here. You know, if we had a big corporation that wants to acquire us, which is like flattered the big check in front of us, like, hey, we're going to give you this amount. It's like, whoa, hard to say no to that. I guess what are some of those things? Because a lot, I could see them getting glossy eyed over just getting the check, but then all of a sudden it's like tied to this earnout, tied to this. Yeah. It's like you're actually only getting this little check at closing, and I'm like, well, what the fuck, you know?
Yeah. No, with putting the seller hat on, it's at the beginning we often just tell them like, please don't give up. Like, especially at the end, deal fatigue is a real thing.
That's a big thing that does not get talked about. Like when you sell a business, oh, wow.
Yeah. You are exhausted. I mean, you've been pouring through diligence. You've been negotiating the business teams. You've been paying your legal team, and the closing's not in sight, right? You start feeling like, is this ever going to happen? My wife wants a vacation. You know, like I need this to close.
We should start like a therapy consulting company just for that.
Yeah.
Like people are going through the sell side process because it is, you're paying all this money out, you know, and sometimes you know, banker's going to want you to do like a seller Q of E, and you're just like, you got them on retainer. You're just like paying a lot of money out.
Yeah.
And then the fact is the buyer's got a whole army of people running doing diligence, and it's just you and the CFO and maybe one or two other people.
Yeah.
It's intense.
Yeah. Or asking for a document that you're like, what is that? You know, like, I don't even know what you're asking me for. Or audited financials. I didn't audit my finances. Like, you know, like more smaller mom and pop companies, kind of things like that. But I would advise, I mean, the one thing is that deal fatigue, right? Is to just be mindful of that. Diligence, it's going to piss you off. And when do you get involved on the sell side? Like if I got the company approached, you know, we got an NDA, all of a sudden they got this LOI they sent. Do I call you and say, hey, I got this LOI, we should review it together? Or do I just sign it and then call you? So what should they do versus what they actually do? They should call us once they get the LOI, not signed. Right? Because we can still negotiate certain things at that point for you.
Yep.
And already set the table of, this is not going to be a walk in the park. I don't care how big the check is. I understand you guys want X, Y, and Z, but we need to protect our client. An LOI that comes already signed, our hands are kind of tied. And at that point, again, we're going to ask for that second NDA to make sure if they get any confidential information from you and this deal does not close, that they cannot use it. I cannot tell you recently how many times it's happened. A buyer has contacted a customer or a vendor before the deal closed, before the seller even told the network that they're planning on selling, and it ruins everything.
That's something I would do. I would like, hey, I want to do some customer diligence. I want to know like how happy of a customer they are, how likely they are to stay.
So you can do that, but you have to do it with seller's consent. You can.
Okay. So I got to let you know. But the seller is probably going to be like, no way, dude.
Well, no. The sellers, I mean, they will figure out a way. Like this is your first opportunity to work really together, right? Business wise. How are we going to approach this? You're probably going to have to, you know, make it nice and sweet of, hey, you're going to be working with me now. You know, it's a good thing. And then seller is going to emphasize, we've had a great relationship. Trust this guy. Probably also going to work a little bit for this guy. So we're not going to be completely detached. So you want to actually communicate with seller.
And then you may even find like a third party that does a lot of this stuff these days. So cool. So we got that. We got our second NDA. As a seller, we kind of talked a lot of the counterpoints that the buyers present that you have to represent and sort of like, hey, protect the seller's interest. Any other key things that are unique outside of what we just discussed and sort of the, you know, both sides?
So the diligence process is, I would say, is different between buyer and sell side, right? So buyer diligence, like you mentioned, we're going to be communicating. I'm communicating with your business team. We're having, I need to have a more aggressive, I would probably say, analytical view of the diligence and how it works with your business and the purchase agreement. As seller, we're being responsive to you, right? So you asked me for this, I'll give you that, right? If you don't ask that follow-up question, I'm not going to give you the answer. And that's that. So that's the difference already in the diligence. The problem is sometimes sellers just don't want to give any diligence, or they just don't have it.
Wow.
And so you have to then figure out, well, how can I get a responsive answer to this, right? So you'll have to have narratives. So you'll have to have, for example, sometimes they don't have customer agreements, so they'll just have purchase orders or something, or a handshake. And I need to figure out, how long has this handshake been going on, right? How often do you pay this person? What exactly do they do? So we have to figure out that. So on seller side diligence as well, I need to understand how your business operates completely. Buyer side, I need to understand how your business is going to operate in mine. If I'm sell side, I don't really care about how it's going to operate in yours. You need to figure that out. I need to figure out how this thing operates to get it legally ready to sell.
Those are the main things. Because we talked through a lot of the other clauses that come up, and they ultimately just get negotiated.
Yeah. And as seller's counsel, we can go a little bit more working capital adjustment, for example.
Yeah.
I'm going to fight as seller's counsel that the way how we have done the accounting is the way it's going to be done. At that point, it's the way how an earnout's going to be calculated. I need all the numbers to match the same calculations, right? Because we can't do working capital this way. Fine.
That's how we do it.
Right. And then you can't do then the earnout the way how you calculate things.
We're a big corporation, and we know better. We follow all the GAAP accounting rules, unlike you.
Right. But then we're comparing apples and oranges, and it's not an accurate representation.
Well, that's why you got to change things. Listen to what we tell you.
Well, no, because we're not going to get the full actual picture. Right. And we don't know how it's going to swing. So you may actually want it to be the way how I've been accounting.
I work at a bigger law firm than you do.
Oh, don't get me started on that.
Does that happen? It does, doesn't it?
That's so the question you asked. I've seen other podcasters. What's the craziest thing in M&A? And I tried to think about clients, and I'm like, nothing's really popping up. And also, out of the sake of confidentiality, whatever. But the craziest thing is always the attorneys on the other side who don't want to negotiate. We'll be on a call. Yeah. We'll do that. Yeah. We send the purchase agreement over with the things that we talked about, and they all get rejected. And it's like, we just said on a call that was okay.
About it, yeah.
And I've had a deal before where I don't know if the attorney wasn't talking to the client, their own client, but their client was talking to our client and funneling terms up to us. And we're like, are you sure? And then they're telling us, no, that's the deal. And then we go back to now opposing counsel, and they're like, that's not the deal. We're like, wait, who lied to who? Right? And now we're trying to figure out what's going on. And that's when you get the 15 people on a call, legal's on, finances on, business teams on, just so that we hash out what's the actual deal point.
That is wild. I've heard variations of that happen quite often.
Mm-hmm.
What's market?
Oof, depends.
This is a really interesting thing, because I feel like
it depends. It depends, because
what's based on? Is it like a LexisNexis database that we say, okay, according to LexisNexis, this is market?
So,
or hey, we've done this a million times and this is market. What is market?
So you can find and it's great that you asked that, because I think it was a third year associate, I asked myself, how do I figure out what's market? And people are talking about market trends. How do I keep track of this? Do I look at Bloomberg or things like that? There are databases online, right, where you could look at trends where, caps are going up to X amount, holdbacks are going up to X amount, for example. However, you don't want to just go off of external numbers, though they can be guideposts. I'm really big on data. Mm-hmm. And so I am probably one of the rare attorneys, even though we exist. I love Excel. So I have my own personal tracker of deal sizes and different percentages, and like, how did we negotiate reps and warranties? How did we negotiate survival periods? If we have rep and warranty insurance, did we change anything else that maybe in another deal we wouldn't have deviated, right? So market, and that's why I said, like, it depends. It depends on in the business sector. It depends on the size of the deal, right? Because some deals I've actually seen escrows go up to like 20%, 30%. But again, it depends on the size of the deal.
You used any AI on deals you worked on?
So I have not personally.
I was going to ask, is AI going to figure out what's market?
So here's the thing about AI, right? What is the data set? It's past, right? So it's relying on that. And so if no one's going to update that knowledge, bank, the AI is not going to know what's market either, right? AI is going to know market at a certain time based off of whatever the model learned at that point. And things can shift, and maybe the model doesn't update. Next thing you know,
somebody's going to market it though. Is that we keep our model
real time.
updated,
Yeah,
real time. Yeah.
Real
as
time.
soon as like deals close, somehow we get that info and update our.
I mean, I think you've just thought about something with SEC Edgar if you keep a tracker on that.
Yeah, because it is all public on those agreements.
Yep.
But would you correlate it to private? Because again, like those little deals, all these things are very different. And
You could probably find certain terms. Yeah, that you could match with. But yeah, no, because sometimes with those public deals, it's just the disclosures and the financial requirements, reporting requirements, regulatory compliance that changes. And so maybe they'll have an extra escrow for that, and you don't have to account for that. So then you'll be like, okay, in my agreement, I don't have to take care of that. But at the baseline, what was the purchase price? What were the percentages? Did they get rep and warranty insurance, et cetera?
Yeah. Okay. So to be continued. So we'll see what happens. And then the contract analysis, I think, is the other big one that we're seeing bubble up more so. I think generative AI has like really made that effective. I got personally involved in developing that last year. And do you see that sort of coming in the field? And
so I've seen it come in the field in the sense of a lot of panels talking about how AI is going to get rid of junior associates.
You're going to get rid of the first and second year.
And I just don't buy that, right? Because
then you'll be able to, because there won't be any crop of future attorneys, but you'll be able to like keep increasing your fees infinitely. Paying like $50,000 plus an hour.
I'd like to retire at some point.
That'll be it. You just like wake up, do an hour of work, and you're good for like a month.
Right. Yeah, no, I think with AI in particular in contract analysis, right, it's good for those specific targets of change and control or, assignments, insurance requirements, things like that, very targeted. But let's go back to the mock trial analysis of understanding the entire universe of the deal, right? I think AI struggles with contextualizing like some of the nuances of some of these contracts and how they play a role with the acquisition, right, or the sale. And I think that's where things get a little bit dicey, and that you need that human touch of, okay, yeah, this contract has a change in control provision. Yeah, we need to flag it, but there may be other things in the agreement that's implicating, like, an indemnification obligation or something. So it can help. I think it's a good complement. I don't think it's a replacement.
Other thing with AI, I was thinking of just the regulations around AI. I feel like it's still pretty undefined, and they're starting to define it, especially like in Europe. Tina, I got to ask, what's the craziest thing you've seen in M&A?
Cash sweeps, where you try to explain, when you sell asset, you're not selling cash, right? And accountants, attorneys sometimes struggle with understanding working capital and the fact that you're not actually leaving cash, right? It's accounts receivable, accounts payable. Things need to balance out, right?
Yep.
And then you will do a cash sweep. But sometimes, well, not sometimes, but there was a scenario where someone swept twice. And so now they owed the other party X amount of money. And it became this whole litigation thing.
Wow.
Where it was like, well, you knew you weren't supposed to take that money. Like,
wow.
What do you mean you didn't know that you weren't supposed to take that money?
Getting greedy in the wire. Oof.
Oh yeah, that. buying a business but not having the requisite permit to
Okay.
actually conduct the business, and then the person that has the permit wants to retire. What do you do then? And it's like, well, did you not do your diligence before of like, can you even do this business? But yeah, there's that. I can share with you my craziest closing story.
Let's hear
Actually,
it. Love to hear it.
second year, I think I was second or third year. This was actually the rep and warranty insurance deal buy side. And there's a certain point in a deal where it does not matter how thorough your memo is. You can't step away because you have so much knowledge with respect to this deal that you can't have someone kind of like step in if you need to go away for a vacation or something. I had a wedding in Mexico City that I just couldn't miss. And the closing kept getting pushed back and pushed back. And I'm looking at the calendar and I'm like, this is going to hit in Mexico City. I know it. Of course, it's the third day I'm in Mexico City. We have to close the deal now. I'm on my way to the pyramids, a UNESCO world site, right? And I am in the back of an Uber on a Mexican highway closing a deal. And I have a picture of me like with my laptop in the Uber. And I just remembered like closing the deal, releasing the signatures, the wires get funded. And, my boss was like, please drink all the tequila for me. Cause it was a long deal. And I'm looking at the pyramids, like, well, not the pyramids, the temples. And I'm like, I bet you they were not thinking that someone's going to be here that just closed an M&A deal with a laptop in the back, like, and just doing some follow-up, like post-closing. Let's make sure we send the closing binder, stuff like that. But yeah, that's the craziest one. The back of an Uber on a Mexican highway.
Then just transport right into ancient history.
Of course. Yeah. Yeah. It gave me a really nice perspective on life.
Tina, this has been an awesome conversation. I really enjoyed it. You've helped me become a better M&A scientist.
Oh, I appreciate that. Well, you've helped me as well. I mean, I shared this with you when we first connected. I heard about your podcast on the Netflix show Partner Track. And that was also at the time where I was looking like, well, what's market? I don't know what these things are. And you had a bunch of these like senior practitioners and even still now, speaking about these topics that I'm like, wait, I don't know what that is. And wow, years later, look at me now.
I love that came full circle. For those of you who don't know, we had a cameo in a Netflix series called Partner Track, which is like a rom-com that takes an M&A law firm. Highly recommend checking out episode 1 and pay attention 20 minutes in the first episode. Yep. But we're plugged in there nicely. And then from that, we've had a lot of attorneys I've noticed. I was like, I got to make a point to interview attorneys. And full circle, you found the podcast, interview. It was a phenomenal interview. And you're like, I think recognized recently as one of the up and coming rising stars for NYC attorneys.
Yeah.
So really honored to make this happen and excited to get this published. Those of you that have listened this far, I love you, fellow M&A scientists. Hit me up. Tell me what you thought about this interview. That's what I get feedback, to get ideas to do these podcasts. Give me a sense of what topics to cover, things like that. Or give me criticism. I don't mind. I'll take it. That's how I'm going to get better at doing this. So reach out to me on LinkedIn. I love hearing from folks that listen to the podcast. Till next time, here's to the deal.